Start. Yeah. Welcome to all the participants for the webcast, for the today's webcast, as well as we welcome to our today's resource person, Mr. Souvik Roy. Mr. Souvik Roy is the partner in IC Universal Legal. Souvik Roy has been partner of the firm since August 2013. He is the member of the transactional practice team focusing on assisting and advising domestic and foreign clients on venture capital investments, private equity investments, joint ventures and merger acquisitions in India and overseas. He brings in considerable experience in advising various clients, including mutual funds, NBFC and real estate developers in their investment, as well as raising capital in debt sector, including debt capital markets. He has advised clients through the lifespan of transactions, leading in on some of the highest value transactions in healthcare, e-commerce, real estate, education, F&B, and banking and finance sector. He also advises on company formation, structuring and early stage business requirement of startups, drafting of various corporate commercial agreements and regulatory compliance. He also brings expertise in advising clients on structuring and formation of investment funds, raising capital from investors, and has assisted several clients in obtaining license on investment funds, portfolio management services, and investment advisory services. He also has a fair exposure in mining laws and has advised clients on operation of mining and energy business. Souvik is the alumni of West Bengal National University of Judicial Sciences. And right now he has been, that one is regular speaker in various assignments on that one is particularly in the startup sphere. He has spent it considerable time in that one is particularly whenever we are talking about the startup certificate course or the startup sphere. Many lectures he has delivered through the Institute of Chartered Accountants of India. So that with this, we welcome Mr. Souvik Roy in this live webcast. Right now, I am handing over the session to Mr. Souvik Roy.
Thank you. Thank you. Am I audible, Sambitji?
Yeah, audible.
Thank you, Sambitji, for such kind introduction. And a warm thank you to the entire ICAI for inviting me to speak on this session, which is titled Understanding Term Sheet, Investment Agreement and Equity Dilution. And last but not the least, thank you to all the attendees and participants who are attending this session. So on this note, I'll start this session. Just give me a moment to put up the screen, the presentation. I hope my screen is visible.
Yeah, sir. Your screen is visible.
Okay. Just a second. Trying to do it a full screen. I think it just got hung or something. Just trying to do it. Okay. Sure. Okay. So let's start with the session, which is called Understanding Term Sheet, Investment Agreement and Equity Dilution. Okay. So before we, sort of deep dive into our presentation and what all I'm going to cover today, so I'll start with a broad introduction about this topic, about this session. Who is it for and at what stage is it required? Right? As Sambitji was mentioning, this is more so to do with the context of the startup ecosystem, and more so in the startup ecosystem, this will be relevant and significant when we are talking about funding in a startup by angel investors, VC investors, P investors, and the likes. Correct. Now, Essentially, just to give a very broad overview of it, a startup is formed when a promoter or more than two or more promoters come together and incorporate a company and form the startup. The initial instruments the promoters subscribe to are the equity shares. They form the company by subscribing to equity shares. They start doing the business either by bootstrapping or infusing their own capital. And at some point during the course of a startup's lifespan, a startup would require an institutional funding. There were different forms of funding, as you would be aware. One is the equity funding and one is the debt funding. So as long as it's the debt funding, obviously a startup can avail those debt borrowings from banks and other financial institutions like NBFCs, etc. But today's session will be more focused on what happens when a startup actually approaches an institution for equity funding, correct? So, and that's where all these investors, the equity investors, either you call them angel investors or the VCs, as we generally know, they come into the realm of the things, correct? So at that point of time, all these concepts and whatever we will discuss and speak today will become relevant, because when an equity institutional investor comes into the fore, there are certain processes, there are certain documents which an investor would generally like to look at, correct? And it starts generally with the term sheet. After initial round of principal level discussions, the investor, you would generally see shares the term sheet with the startup. And then, there are certain sequences which flow chronologically, which we will cover. So let's start with this term sheet. What exactly is a term sheet? What is covered in a term sheet and what happens from there, right? So term sheet forms a part of the investment document. Let me just go to the next slide. Yeah. So as you can see, there are different sets of investment documents which are relevant in an equity funding scenario. Now, what sort of documents are there? One, of course, is the starting point is a term sheet. As I mentioned, I'll come to what exactly a term sheet means and what exactly a term sheet captures, etc. There are other certain documents, apart from the term sheet, which are miscellaneous or ancillary to the transaction, like a non-disclosure agreement. So non-disclosure agreement technically will be a confidentiality agreement, which kind of imposes certain confidentiality obligations on the prospective investor, because before investment or at the time of investment, there are a lot of confidential or proprietary information which is being shared by the company or the founders to the investors, right? Because those are important, those are required to be shared to the investor so that the investor conducts all sort of diligence on the company on various aspects, be it legal, financial, tax, commercial, etc. So non-disclosure agreement at times becomes important. And there are certain other miscellaneous agreements. I will touch base upon them as we go forward in the session, with the disclosure letter, employment agreement, which is to be entered with the founders of the key management employees at the company, IP assignment agreement or the intellectual property assignment agreement, which is essentially executed by the founders, whereby they kind of assign all sorts of intellectual property developed during the course of employment to the company on an unconditional and a perpetual basis. And obviously, there are charter documents of the constitution, documents of the company on the likes of articles of association, etc. Now, obviously, term sheet is the starting point of this entire set of transaction documents. So once a term sheet gets signed, the investor and then the investor conducts all the diligence, etc. Then that is a set of definitive agreements which get executed between the parties, that means between the investor and the promoters. Now, what sort of definitive documents are that? And that's where the sort of the left-hand side column details mentions all these definitive documents. Now, there can be different sort of definitive documents depending on the kind of transaction, the nature of transaction, or rather the nature of securities which are being subscribed by this potentially. One, of course, the first thing you would have come across, you would have heard, is the share subscription agreement. Share subscription agreement becomes important when an investor is subscribing to shares. We will again discuss in broadly what all is there in the share subscription agreement. But a share subscription agreement or an SSA will broadly contain the terms and conditions for the investment, the amounts, the types of instruments, the representations, warranties, all the conditions precedent, the indemnities, etc. If the instrument share is in the nature of a debenture, then it will call it a debenture subscription agreement. If it is the nature of a warrant, then it will call it a warrant subscription agreement, right? So these are the three, primary form of instruments you would have converted. Also, nowadays you would have seen or note that the instrument is in vogue. So if the investor is subscribing to convertible notes, we'll call it a convertible note agreement. So these are all the agreements, which an investor executes or the parties execute if the investor is putting money in the company against subscription to a very specific set of securities, be it in the nature of shares, debentures, warrants, convertible notes, etc. Right? So then all these documents get executed. Now, at times, a transaction is also structured in a manner that the investor, instead of putting money directly in the company, you would have seen is buying shares from a promoter or an existing investor or an existing shareholder, as the case may be. In that case, the document which is generally executed is called the share purchase agreement, or the SPA, right? And which would obviously contain terms and conditions for such share purchase. What are the conditions precedent for such share purchase? What are the representations warranties given by the seller to the buyer? Any corresponding indemnities and so on and so forth, right? So then the transaction is more so between the buyer and the seller. And apart from that, there is another substantial material document which gets executed that is called the shareholders agreement. Right? We'll obviously sort of go into detail on what all a shareholders agreement contains, what all it captures. But to give a broad overview, like the subscription agreements, as I was mentioning, would generally contain the broader terms and conditions for the subscription, like what is the amount, what are the securities which are being subscribed, what are the conditions precedent required to be done by the company and the founders for the securities to be subscribed, what all representations and warrant by the investor for this investment, what are the indemnities being sought by the investor. So these are all linked with the terms and conditions for the investment. Whereas the shareholders agreement generally comes into effect once the investment happens. So from the investment date, the shareholders agreement comes into effect. Now, what is a shareholders agreement? To put it very broadly, a shareholders agreement is a document which captures the rights and obligations of the parties inter se. That means it will capture the rights and obligations of the promoters of the company and the investors between themselves, as well as vis-a-vis the company. Correct. So that is more of a substantial document which is going forward. So once the investor is invested in the company, what are the sets of rights and obligations which govern the different parties, like what will the promoters' obligations be towards the investors, towards the company, what are the investors' rights are against the company, against the promoters, and so on and so forth. Okay. So moving on. So this is about the broad overview of what the investment documents generally look like. Now, starting with the overview of the term sheet and what all a term sheet generally contains. Right. So as I was mentioning in the previous slide, so there are different set of transaction documents, starting with a term sheet and going with the different set of definitive documents. Now, why do we need all these different agreements, or more importantly, what is the difference between a term sheet and these definitive agreements, unlike on the nature of the SSA, SPA, SHA, which I was talking about, right? Now, to put it broadly, term sheet is something, which is a starting point of a transaction, as I mentioned a while ago. So the investor promoter, after a round or couple of rounds of commercial discussion, if prima facie investor finds any substance or finds any good reason to invest in, or finds any viable proposition to invest in, it will share the term sheet. Right now, what exactly is a term sheet? Term sheet, you can kind of put it at the same footing as a memorandum of understanding or an MOU, or more on the likes of letter of intent. Right. Now, what do I mean when I say these things? Essentially, the purpose of the term sheet, and there is a very distinctive purpose of the term sheet in the definitive documents, like definitive agreements, in the likes of the SSA, SPA, SHA, etc. A term sheet is merely intended to line the proposed transaction, right? So what it means is that it kind of puts forth only the key commercial and strategic terms. It is not intended to sort of elaborate in detail the rights, obligations of the parties, different parties between themselves, etc. And that's exactly the job or the purpose of a definitive agreement. So that's why, to put it in context, that's why term sheet becomes a starting point of a transaction, which will only outline the broad contours of the transaction, or the key commercial, or the key features, or the key rights and key commercial terms, key strategic terms of the transaction. Rather, so essentially, you can say term sheet as a document, which kind of captures the intent of the parties, right? It's more of a soft commitment that way. And why do I say it's soft commitment? And why I'm saying it's like captures the intent of the parties? Because term sheet, if you see, or if you have come across, you will notice that it is generally not a binding document, right? Unlike a definitive agreement, or unlike a contract, which is in the nature of the subscription agreement, shareholders agreement, share purchase agreement, etc. A term sheet is an agreement or is a document which is generally not binding, right? Because it's more of an agreement where the parties kind of say that, we agree that we will agree at a later point of time. That means we'll agree in the definitive agreements. It does not create any legally binding intentions. Again, it is merely to capture the commercial intent of the parties. That emphasizing on this term, that is a soft commitment as opposed to hard commitment, right? And as I'm mentioning, it is generally not binding, obviously, unless otherwise expressed in the term sheet or in the MOU, as you may call it, except there are certain clauses, like obviously, as I was mentioning, confidentiality will be an important feature, because there will be a set of confidential information which will be passed by the company and the founders to the investors to evaluate their whether the making this investment is feasible or not. Exclusivity is something which will also be important feature. Exclusivity is nothing but is kind of a timeline which the company and the founders agree that since term sheet execution of the term sheet kind of portrays this soft commitment of the investor to invest in the company, subject to obviously certain conditions being fulfilled by the company and the founders. So thereby the founders and the company also kind of commit, there will be a certain time period post execution of the term sheet, during which they will also not solicit funding or reach out to any other potential investors or any other potential third party for their funding, right? Because otherwise this entire discussion and the process will get defeated if parallelly the founders and the company are also having multiple discussions with different investors. So right, so that's why exclusivity clause is something which is generally considered as a hard commitment, because it is intended to portray it's a hard promise, and dispute resolution is something which is also a kind of a binding clause. So that's broadly about what the term sheet is. And how is it different? Of course, it's the precursor to the definitive agreement stage. So, to put it broadly, once a term sheet gets executed, the investor proceeds to undertake the diligence of the company, of the target company, on all the aspects, be it the legal diligence, financial diligence, tax diligence, and the commercial diligence. Post the completion of diligence and subject to satisfactory findings by the investor, then the investor proceeds to draft and negotiate the definitive agreements. Definitive agreements, as I was mentioning, that can be of different types depending on the nature of the transaction, depending on the securities. But generally, if in an equity funding transaction, you would see a share subscription agreement and the shareholders agreement, which are being drafted, negotiated, and finalized between the parties. Now, what are these? Again, as the name suggests, they are the agreements. They are intended to capture in detail the rights and obligations. They will detail out the transactions. So essentially, you will find generally the rights and obligations being captured in a detailed and exhaustive manner. And this is the stage where the hard commitment is made, right? That means obviously these documents are binding in nature. They will be enforceable. And by this, I mean that the aggrieved parties will have the necessary remedies under law and the contract, correct? Similarly, they will be admissible in evidence, and that's why you will see the necessary stamp duties being paid on these definitive documents, depending on the place where they're executed. Unlike a term sheet, where it is not being executed on a stamp paper, because again, it's not a binding document; it's not intended to be binding document. And and they are the final set of documents under which once the aggrieved parties sign, they are kind of signing on the dotted lines, and there will be implications if there is a breach, so on and so forth. So this is broadly the difference between a term sheet and the definitive agreements. Now we'll go to understand what all clauses or what all key rights and obligations a term sheet and a shareholders agreement, the definitive agreements generally capture in an equity funding transaction. Let's say when a VC investor, when an angel investor sort of comes and invests in the company. So before that, I'll first start with the types of instruments which an investor generally seeks to subscribe in an equity or equity-linked funding transaction. And there are various different types of instruments which are envisaged under the applicable laws, and depending on the nature and the stage of transaction and the commercial comfort of the parties, the instrument is finalized. Now, what are the different types of instruments, right? Firstly, we'll start with the equity shares. Equity shares, as equity shares, the ordinary shares, in whatever name you call it, they are such instruments which kind of ascribe an ownership in the interest of the company, right? So these are the instruments which kind of affirm your ownership in the interest of the company, which portray ownership interest apart from the equity shares. It's important to keep it in mind, no other instrument will entitle an ownership right in the interest of the company. correct? So equity shares is something which entitle the holder of that to have the ownership right in the interest of the company. That's one. So along with the ownership right, the other right which kind of naturally comes along is the voting right. Correct. So you would have seen or you would have come across that equity shareholder has an ownership right in the interest of the company, and also parallelly he has a voting right pro rata to his shareholding, equity shareholding in the company, and voting. And what exactly is the voting right and all? I'll kind of dwell into it in a bit. But broadly speaking, yeah, obviously in certain matters of the company, as a shareholder, as an equity shareholder, such equity shareholder can vote on those matters of the company to the extent of the equity shareholding he or she holds. Correct. So this is an instrument which is being obviously which is the most prevalent and which is broadly used by the founders at large, because as I was mentioning, when the founders come together and incorporate a startup, they usually start by subscribing to the equity shares, because equity shares will be needed to incorporate a company. And apart from that, now apart from the equity share, there is another type of shares. At times the founders use it, but that becomes more prevalent for the investors, and that is preference shares, right? Now, what are preference shares? Preference shares broadly are those instruments which kind of give the holder preference right to equity shareholders on certain aspects. I'll come to that. But before that, more importantly, a preference shareholder does not have any ownership in the interest of the company. That's one important thing to remember, right? It does not have any kind of ownership by but merely by holding preference shares. And secondly, ideally, a preference shareholder also does not have, since it does not have an ownership in the interest of the company, a preference shareholder also would not have voting rights in the company. Having said that, there are certain flexibilities which are provided for the private companies under the Companies Act. And it's quite helpful accordingly to structure all this equity or the VC investments in a way by which you can sort of extend all the voting rights to preference shareholders and have them at the same footing as equity shareholders, as at least in terms of voting rights, etc. Now, this is about the voting and the ownership rights of the preference shares. So what else? So why is it called the preference shares? It is called a preference share primarily because it provides the holder of the preference shares a preference vis-a-vis the equity shareholders in terms of, one, as a dividend. So whenever a dividend is being paid out from the profits or the reserves of the company, a preference shareholder will have a statutory preferential right over the equity shareholders. And secondly, in terms of any winding up or liquidation or dissolution of the company, any kind of proceeds which are being distributed by the company to the shareholders, specifically, then the preference shareholders will have a preference over the equity shareholders to the extent of the distribution of the liquidation proceeds, right? Now, this is an instrument which is being widely sought by most of the VC investors, angel investors, etc. Now, there are different sorts of preference shares. One of them, and which is extremely prevalent amongst in the VC ecosystem, is the compulsorily convertible preference shares, or the CCPS. What does it mean, right? Now, firstly, as the name suggests, the CCPS, by its very definition, since the compulsorily convertible, so they are mandatorily convertible into equity shares in accordance with the terms agreed between the parties. And of course, the Companies Act provides certain key conditions for those conversion, etc., of the preference shares. But yeah, but the most important feature is that CCPS have to be mandatorily convertible. What do I mean by that? At times, you would have seen that there are preference shares, instead of getting converted, can also be redeemed, by which that you do not need to essentially convert into equity shares, but you can just, sort of in lieu of the preference shares you hold, you will get the money invested or you will get the redemption amount. But that will not be possible when we are talking about the CCPS as an instrument. It has to be mandatorily convertible. Now, the Companies Act does suggest an outer timeline by which they have to be converted, and that is a period of 20 years, right? So from the date of issuance, they have to be mandatorily converted into equity shares within 20 years. Now, as an equity investor, mostly as a VC investor, generally would have seen no equity investor stays for a period of 20 years. So that's why, it's also contractually agreed that either within the 20 years or before the IPO, because when the company goes for an IPO, in all likelihood, SEBI would ask the company to convert all those preference shares into the equity shares. So either it becomes contractually agreed, earlier of 20 years or the IPO. certain shareholder rights, as I was mentioning, certain preferred shareholder rights with the CCPS provides, that is the payment of dividend and liquidation proceeds, which prior to the equity shareholder, which comes directly from the Companies Act. Now, in terms of the voting rights, right? Now, as I've said that preference shareholder, the CCPS or the preference shares of the CCPS holders will not get an automatic ownership right, unlike the equity shareholders. However, as far as the voting is concerned, and that becomes a more important right for the investor, because when the investor puts in the money, he's also trying to protect or safeguard his rights and interests, vis-a-vis the various operations, various decisions will be taken by the company in terms of crucial matters of corporate governance, in terms of important matters of its corporate restructuring, etc. And that's why voting on those items becomes an important part for an investor rights, right? When we're talking about an equity funding. And so as I was mentioning, and you would have seen most of this investment, sort of 99.9% investment happening in the private companies. So the Companies Act provides this flexibility for the private companies to structure, have malleable voting rights for the CCPS holders. That means the voting rights can be extended at par with the equity shareholders even for a CCPS or a preference shareholder in a private company. So that kind of gives them the right for an investor. So and the way they generally structure these investments, and you will see in a share subscription agreement or a shareholders agreement that despite those investors holding those CCPS, the voting rights are generally on as converted basis. And by that I mean that, let's say they're holding 100 CCPS, and each CCPS gets converted into one equity share. That means they will be holding 100 equity shares, and assuming that 100 equity shares constitute 20% of the equity capital or the paid up capital, 20% of the capital, because as you know, preference shares will not give you an entitlement to the ownership. So to calculate the ownership, you have to do it on as if converted basis. So to assume that they have been converted, and assuming that, as I was saying, that once you do the calculation, let's say 100 CCPS for an investor gives 20% ownership rights on as if converted basis. So essentially, you can even structure those CCPS held by the investors will have a 20% of voting rights. That means the same voting rights as the ownership of what the equity shares will provide to the investor. Correct. So that is voting on a CCPS or voting on a preference shares is kind of flexible as far as a private company is concerned, and investors can have the voting rights at the same on an as if converted basis. That means even on a preference shares, they can have the voting right, assuming they have been converted into equity. So that's broadly about what a CCPS constitutes. Now there are other kinds of preference shares which are not so very much used by an VC investor or an equity investor, and kind of explained by so I'll briefly touch upon them. One of them is the optionally convertible preference shares. Why it is not used? Because as the name suggests, it is not necessarily convertible into equity shares. It's optionally convertible. That means that it not only has an element of conversion, it also has an element of redemption, right? And when you say there's an element of redemption, that means that in lieu of the instruments you hold, the holder can ask for the, whatever the agreed redemption amount to be paid, instead of converting those instruments into equity. So it's broadly and commercially, which it essentially means is that there is kind of an assured return element which can be linked to such OCPS. That means there is a flavor of debt which can be linked to such instrument, right? So that's why, such instruments may not be in such vogue when you're talking about VC investments or angel investments, because as you know, they're more of the equity funding, and by equity funding, we mean that necessarily the holder will need to take that equity risk, correct? And by linking all those, sort of elements of debt and redemption, it loses that equity flavor. It kind of becomes a more of a hybrid or a debt flavor instrument. Having said that, again, as I was saying for the CCPS, even the companies that suggest they have manually converted or redeemed within 20 years from the date of issuance. Now, nextly coming into another sort of instrument, which are the debentures, right? Now, what are debentures? Now, shares, as I was mentioned, there are two types of share capital. That's one, the equity share, one is the preference shares, and the ownership is for the equity shares, and the preference shares are limited rights. However, there are certain contractual flexibilities for a private company which you can provide. Now, debentures, on the other hand, are not to be considered as shares till the time they're converted into shares. They're more considered as a debt in the sort of liabilities of a company, correct? Now, what are the different kinds of debentures, and what is the and if at all debenture finds flavor in the, in the realm of the VC investors or the equity investors. So one of them is compulsorily convertible debentures, or the CCDs, right? Now, what are they? They are those instruments of their debentures which primarily are debt instrument. But having said that, since they are compulsorily convertible, as the name suggests, they have to be mandatorily converted into equity shares or the preference shares as per the terms agreed between the parties, right? So, it's as good an instrument, because at some point, but very technically speaking, till the time they are converted, legally speaking, they are to be considered as debt instrument. But there is no element of redemption again. So though you can structure it as a debenture, but it's kind of a quasi instrument because they have to be converted into equity share. Again, the Companies Act and the necessary provisions suggest an outer timeline for such conversion, which is like the 10 years for the debentures. So they have to be mandatorily convertible within 10 years from the date of issuance. Again, as I was mentioning, in the case of CCPS as well, when an investor comes into the play, he generally negotiates either the earlier of the 10 years or when the company is going for an IPO, because that's when, as I was saying, say, we would ask the company to convert all those things into equity shares. Now, what is one important distinction between the CCD holders and, let's say, an equity holder or a CCPS holder? Obviously, since I was mentioned at the start that the debenture is not to be constituted as a share, hence a debenture holder will not be constituted as a shareholder. Hence, all the statutory rights or all the rights which the Companies Act and the different rules provide to a shareholder kind of will not be available for a debenture holder, and by debenture holder, even a CCD holder, right? Because till the time a CCD is converted into equity, legally speaking, see the debenture. So hence, all the statutory rights of a shareholder will not be available to a CCD holder. And one of the very important rights is the voting rights, correct? So voting rights generally will not be available to a CCD holder because the debentures cannot be issued with the voting rights. And hence, a CCD holder will have only limited rights, which can be conferred upon them contractually, at the same time ensuring that they do not violate or go against the spirit and the letter of the Companies Act. Right, because we have seen there have been instances where if the companies have tried to extend all sorts of voting rights, what is available to a shareholder, to a CCD holder as well, but then different regulatory authorities have come and raised apprehensions and concerns, and rightfully so, because since the statute categorically prohibits a debenture holder to have voting rights, kind of treating it the same way as a CCPS holder, the equity holder may also give it in the nature of circumventing the provisions of the Act in letter or in spirit. So that is one important difference between a CCD holder and the CCPS holder. Having said that, there are certain benefits as well to a debenture holder, and one of them being, since the debenture holder kind of stands in preference in terms of a share when it comes to the distribution of the proceeds at the time of liquidation, winding up, etc. Because debenture, technically speaking, is still a kind of a debt instrument till the time it's converted to a share. So debenture holder will be treated the same par as a creditor, secured or unsecured, depending on whether those debentures are secured or unsecured, when the company is distributing those proceeds out at the time of winding up liquidation, etc. So essentially, a CCD holder will kind of be entitled to his proceeds in preference to a preference shareholder at the time of liquidation thing, correct? And definitely in preference to an equity shareholder. So that's a limited benefit which is extended to a CCD holder. Correct. So depending again on the commercials, on the nature of the investment, and what exactly an equity investor or an investor is seeking or looking for in that particular investment, and the stage of the investment. That's why I'm saying these factors will be important to deliberate and finalize on the particular type of instrument. CCPS, again, as I was saying, we'll find that it's the most traction amongst the VC investors. It is the most in the vogue. CCDs, as I've said, there are quite a lot of limitations. Depending on what exactly the investor is looking at, whether he's looking to get the proceeds in preference, and also, he or she can make that call. Apart from the CCDs, there are a few other types of debentures. Having said that, those debentures are kind of in the nature of, again, the debenture suggests in the nature of the debt, has the debt element as opposed to more of an equity element. Because the other type of debentures is the optionally convertible debentures. So as the name suggests, they can be either converted or can be redeemed, correct? So unlike CCD, which has to be necessarily converted into equity share, that becomes a quasi-equity instrument. And OCD is not a quasi-equity. I mean, it's more, it has both elements of redemption and conversion. And by redemption, obviously, it will give the flavor of the assured return. It takes the element of a debt instrument. And hence, it does not find too much flavor even among the promoters when it is looking for the equity funding. Because obviously the idea is clear, because the promoters in the company will be looking out for investors who are willing to take that equity risk in the company, right? So the instruments have to be also be deliberated and finalized accordingly, and not to give a flavor of the assured return or a redemption flavor to it, right? And so is the case of the non-convertible debentures. So non-convertible debenture, or as the name suggests, is that it cannot be converted. So it is a classic debt instrument. It has the only element of redemption. So it is the assured return for an investor. Correct. In both these cases of OCDs or the NCDs, there are certain statutory risks also which flows, and one of them, which I kind of highlighted here, if you're talking about an individual investor, trying to subscribe to these instruments, there is a risk, and the risk is that if they are not fully secured, the OCDs or the NCDs, then there is a risk of deposit under the Companies Act. That means an individual investor subscribing to OCDs or NCDs, which are unsecured or which are not completely secured, it can also invoke, be constituted as a deposit in the Companies Act, by which it means that, there are a lot of other conditionalities, restrictions, prohibitions, which come into the play with the companies going to raise deposits, and if it comes under the definition of deposits, right? So those are the things which also bear in mind. But having said that, let's say CCPS, as I'm mentioning, there are a couple of other instruments before and post that I will sum up the instruments chapter. So I've covered these shares, and by equity shares, different sorts of preference shares, different sorts of debentures. Now there's another instrument at times you would see investor subscribing, and that's a warrant, right? Now what's a warrant? A warrant is primarily an instrument which kind of, does not give the investor any kind of shareholding or any kind of entitlement to any shares, be it a equity share or be it a preference shares. But what it does is that it gives the investor a right to subscribe to certain equity shares at a future point of time, right? So by subscribing to warrants, the investor is essentially buying the right or purchasing the right to subscribe to equity shares at a future point of time, and that those subscription or those conversion of warrants into those equity shares will happen at a future point at a predetermined price, and the price which will be determined upfront at the time of subscription of warrants. So the subscription of to the equity shares that will happen at a future point of time, but the price will be predetermined, and obviously the number of equity shares which the investor is entitled to be subscribed, that also will be determined upfront. Correct. So essentially, as I was mentioning, that it merely gives the investor a right to subscribe to a certain amount of equity shares at a predetermined price and at a future point of time. Correct. So that is one. Secondly, how does a warrant generally play out? One is that at the time of subscription to warrants, obviously, since the investor is not going to get any shares as such, so obviously the investor will not pay the full money, because exactly what investor is doing is that by subscribing to warrants, it's only merely purchasing the right to get those shares. So accordingly, only a part consideration is paid upfront, and the entire balance consideration is payable when the conversion of warrant to shares event comes. So, and by part, it's generally contractually agreed, but you won't see much of the consideration flowing at the time of subscription to warrants. Not more than 10%, or at best you will say, let's say 25% of that entire share subscription being paid upfront to subscribe to warrants, but not more than that, right? And the understanding, of course, is that so only upon the payment of the balance consideration, the investor will get those shares at the price which has been determined upfront. If the investor fails to pay those considerations on that warrant conversion event, obviously, the upfront consideration which is being paid by the investor will be forfeited, because those warrants will not get converted into equity shares. So this is more of a hybrid instrument, and investor, again, depending on the kind of transaction, the nature of the transaction, may choose to also have warrant as another additional instrument to invest in. Just to give a perspective, you may have seen, or you would see that, at times venture debt investors, at the time of, while they subscribe to debt capital in the form of OCDs or the NCDs, they also try to subscribe to certain warrants, because the rationale is that while they're investing in debt instruments, they also want to participate in the equity upside. So Hence, they also kind of try to safeguard their interests or try to have have subscribe to certain warrants to at least buy the right to subscribe to equity shares at a future point of time, right? Because if they see some value or growth in the equity value of the company, so that is an instrument. At times, you would see a venture debt, more so in the venture debt investor is quite inclined to subscribe to certain warrants to participate in the equity upside in the future, right? So that's about the warrant broadly. Now coming to the other sort of instrument, and which you would find a lot of flavor in specifically in the startup ecosystem, is the convertible note, right? So what exactly is a convertible note? A convertible note primarily, when it is issued or when it is subscribed by an investor, it is in the element of a debt instrument, correct? Now, having said that, though it is initially can be treated as a debt instrument, it does have the elements of converting into equity share or the preference shares, right? And so convertible note, as you can see, is more of a hybrid, which has both the elements of converting into an equity or the redemption of that note and paying a fixed return or assured return in the hands of the investor, correct? So it has got both the elements of the equity and the debt, but till the time again it is converted, it is to be treated as a debt instrument, correct? Now, on viral circumstances, convertible note is gaining traction or is becoming more prominent is, when a company, let's say, has already raised institutional round of funding, and there is going to still be some time before it approaches for the next round of institutional fund investors. So let's say Series A funding has already happened, but there's going to be still some time that the company, will reach out to potential Series B investors. But in the meanwhile, if the company needs the working capital for its growth expansion plans to achieve that required valuation at which, it feels comfortable to raise the Series B funding, that's an important phase where this, bridge funding. So that is a phase which we generally call commercial parlance, you call it bridge funding. So that's a phase where convertible note as a instrument is gaining much more prominence in the startup ecosystem, right? And why exactly so? Because again, of its flexible structures, malleable elements of both debt and equity. Once, of course, these investors who are putting those money in the bridge round of funding as a convertible note, since they are kind of helping the company to bridge the gap between these two institutional rounds of funding. So you would often see that their conversion terms or their conversion elements are generally linked to a certain discount to the next round of valuation, correct? So it is more so to provide those incentives to those investors who are kind of helping the company in this bridge round by extending certain capital, so that the company is able to grow and at a sort of desired rate and so as to be achieve that milestones to get the desired valuation at which it gets the next round of institutional equity funding. And hence, to provide those incentives, the founders in the company would generally see that link those conversion terms to some discount of the next round of valuation, right? So let's say to 20% discount or 25% discount. That's again is a commercially agreeable term between the investor and the company. But that's one element of conversion you would see in a convertible note, correct? So that's one. Again, the way you can structure the convertible note is that, let's say, assuming, so one, of course, is that conversion being linked to discount to the next round of valuation. Secondly, what happens, within a certain timeline, if the company is not able to raise that next round of equity institutional funding, then obviously the investor can ask for redemption. And that's pretty much possible in a convertible note, as I was saying, because it's quite flexible. It has got both the elements of the equity and the debt, and it's primarily to be treated as a debt till the time it is converted to equity. So obviously, the investor, because the rationale behind is that investor saying that, this is not a money which I am going to keep it for perpetuity. This is a money which is kind of the investor would also want to be treated as equity because it reaches that desired valuation for the next round. But what happens if the company fails to raise the next round within a certain timeline? Then the investor can say, okay, look, then, you clearly sort of, for whatever reason, have not been able to raise that desired thing on which the promise has been made. So at this point of time, obviously, there's no question of conversion. Then I would like to be treated as a debt instrument. And then I would like to be, sort of paid assured return on this instrument. So it can parallelly take the flavor of a debt instrument, right? So these are these flexibilities which the convertible note provides. So it can, as I was said, it can generally is converted into equity or the same equity linked instrument for the next round of funding, and the conversion mechanism is kind of linked to certain discount to the next round of funding. If the funding does not happen within prescribed timeline, it usually is redeemable, right, with an assured return. Again, the Companies Act does suggest there is an outer timeline for a period of 10 years from the date of issuance of this convertible note, by which you can either convert or have to redeem it. Right. So that's broadly the key features of a convertible note. Apart from that, yes, the Companies Act does provide that a minimum of investment of 25 lakhs as a single tranche needs to be made for a convertible note investor. And as I was saying, it has been sort of, it is much in vogue, and it has been, sort of quite proactively validated and enabled under the Companies Act and the FEMA regulations for specifically for the companies who have been sort of registered as startups under the DBIIT. And, again, you will see a lot of convertible notes happening between these two rounds of funding, or when a companies need of urgent cash, you would see a lot of these convertible notes coming into the play. With such having flexible conversion and the redemption terms, right? So on with this, I the sort of subject on the chapter on the types of instruments comes to an end. So as I was discussed, so we've discussed the different types of shares capital with equity preference, debentures with CCDs primarily being invested, OCDs, NCDs, and then there's some hybrid instruments of the likes of warrant and the convertible note. So now moving on what all the term sheet and the SHA generally contains, right? So, just a second. Yes. What are the key provisions you may come across in a term sheet and correspondingly in a shareholders agreement? One, of course, who the parties are. Now, since we are talking in the context of an VC or the angel investor, you would see the parties being the company promoters and the VC angel investors. And at times, if there are any other shareholders in a startup, be it in the form of existing investors or a key employee having any shares, or an advisor having any equity shares, advisory shares, we may also see the other shareholders, the other minority shareholders, whoever there are, also becoming parties to the term sheet and the SHA, correct? So that's the parties bit. Next, you would see a term sheet generally containing the transaction description. A transaction description is nothing but the amount which is being proposed to be invested by the investor, the kind of instruments which is going to be subscribed by the investor, and so on and so forth, and what the pre-money valuation would be at the investment is happening, correct? So that's the transaction description. Next, you will find there are certain conditions which are generally being laid out broadly in a term sheet, and which are being laid out in much more detail in a definitive agreement, be it in a share subscription agreement or a debenture subscription agreement, as the case may be. What are those key conditions which an investor generally asks the company and founders to complete before it invest in the money? One, of course, is, because as I was saying, that once the term sheet gets signed, then the investor and his advisors conduct diligence on different aspects of the company, right? So investors' councils will conduct a legal diligence on different aspects of the company. Financial advisors will conduct a financial diligence, tax advisors will conduct a tax diligence. So based on the findings, and this diligence is nothing but, ascertaining the legal, financial, or the tax health of the company in all its aspects, and kind of identifying if there is any sort of upfront liabilities, if there is any violation of the laws, if there is any non-compliance, and then, that's how the advisors will list out in what all aspects the company is non-compliant, either it is contract, if there is a breach of contract, non-compliant with the applicable laws, if there is any violation, etc. And accordingly, a list of what all remedial and corrective actions would need to be done by the company and the founders generally gets chalked out, right? And generally gets discussed between the investors and the founders and gets finalized. So these are the action items, based on the findings of the diligence. If the investor finds that there are any key action items required to be done by the company and the founders, key things required to be corrected, required to be rectified, remedied, any sort of housekeeping things required to be done by the company. So those all will be listed as the part of the conditions precedent. That is, those are the conditions which the company required to be done, which the company requires to do before the founders before the investors put in the money, correct? So that's one set of conditions precedent, which are based on the findings of the due diligence, right? There will be other set of conditions precedent which are more customary and statutory in nature, because as you would be aware, for a company to issue securities to an investor, there is set of obligations or an action items required to be done by the company under the Companies Act and various rules, including passing of the necessary board and shareholder resolutions. Again, you would be aware that different modes to raise this equity capital, like the rights issue process or the private placement process, or depending on which avenue the company is seeking, there are again different specific action items listed down for a company to do to complete these processes. Okay. So those are the customary, the statutory CPs. Again, apart from that, there are certain again key CPs which can be unique or which can be specifically coming from the diligence exercises, like the clearance of any statutory liability which the investor may require the company and the founders to clear it out before it puts in the money. Any kind of conversion of promoter loans, if the promoters have given the loans, definitely the investor may ask those loans to be converted into equity, because as you know, loans would have a preferential standing to any kind of shareholder equity or preference. So if from an investor standpoint, that can also be a concern, because tomorrow if the company goes kaput, then obviously promoters' loans stand to get paid in preference to their money, right, which the investor has put in. So for these obvious reasons, the investors can also ask to convert the promoters' loans into equity, because obviously the promoters in all aspects should be coming sort of subservient to the investor as far as payment of any proceeds are concerned. That's how the investor looks at it, right? So yeah, so these are broadly about the conditions precedent. Now again, this will vary from the transaction to transaction based on what all the diligence findings are, based on the kind of company and what all issues it has. Now moving on, so this was about the conditions precedent. Now obviously valuation I touched base upon, at what all pre-money valuation this investment is happening, that also gets listed, that also gets mentioned in the term sheet. Now coming to the more substantial rights, which you generally find broadly or sort of in a curtailed manner in a term sheet, but whereas you find those much in a detailed format in the SHA, right? So, and that's starting with the corporate governance rights. What are the corporate governance rights? Corporate governance rights are broadly can be categorized into kind of 2-3 baskets. One, of course, is the board rights. One is the shareholder rights, and the third will be probably veto matters or reserve matter rights. Correct. So what are the board rights? Now, for an investor, for a VC or a kind of an equity investor, it becomes important because when it is putting in the money, it's kind of participating in the equity risk of the company, right? So the dynamics and the equations are very different from a debt investor, because debt investor, as you know, has a kind of very fixed return, assured set of return. So the kind of interest, the entire amount which is going to be paid is kind of determined upfront, and it's the kind of owners of the company and the founders to pay the money back. And if it's secured debt, the trader would have a certain collateral as security. However, things are not exactly the same for an equity investor. And if a participant in the equity capital, means the returns are quite unlimited, right? There's no fixed return as such, unlike a debt investor. But having said that, the risks are also unlimited, right? So to make sure there is certain degree of protection for its rights, interests, etc. So that's why generally you would see a VC investor or an equity investor seeking certain board right, primarily to ensure that how the company is operating, because as you know, the company takes most of the decisions, most of the operational decisions, the day-to-day decisions at the board meetings, and those decisions are taken by the directors on the board of directors, right? So to that extent, it becomes important and imperative for an investor to have its nominee in the board, right, to have its say in all those matters. Right, so they're in the nature of the financial investors, because the principle is very clear for an let's say an angel investor or a VC investor. More often than not, you would see they're participating purely in the capacity of financial investors and not in the capacity of strategic investors. And by which I mean that those investors, you would see they are not participating in the day-to-day matters. They are not conducting the day-to-day affairs of the company. Correct. So they will be playing more of a dormant role. But again, since it's an equity capital, they're participating in the equity risk. It becomes imperative to ensure there's necessary and sufficient guardrails to ensure the company is moving in the right track. And so one of the ways to ensure is that they have a nominee on the board of directors and when there's a nominee, that means they have a right to appoint a director on the board of directors of this company. So that's where the right to appoint a director comes into the play. At times, you would also see that, they also have a right to appoint an observer. Again, depending on who the investor is, whether it's an institutional investor or not, how much stake it is holding, you would either see a, director and an observer, right? And at times you would see either a director or an observer, right? Or at times you can see just a director or just observer, right? It will again depend on transaction to transaction. But to give a broad overview of it, what are the key differences? A director, as I mentioned, is a nominee of the investor who will be a director in the board of directors. That means he has a right to attend the board meetings. He has a right to vote at the board meetings. So essentially, all the rights and obligations of a director, as envisaged in the Companies Act, get extended to the nominee director. Correct. Whereas an observer is more of a contractual post. Correct. It doesn't come under from any statute under the Companies Act or any other act. So, which essentially means that observer will not have any right to vote because it's not the same footing as a director, but he will only have a contractual right to attend those board meetings, right? So, as the name suggests, he merely has a right to observe and be as a participate in the capacity of a spectator, what is happening in the board meetings, but he does not have a right to vote. Correct. So, yes, so both the directors and the observer will have a right to receive those board meeting notices, agendas, minutes, etc. That's how it flows. Now, in terms of directors, there are two sets of directors. We generally see that executive directors versus non-executive directors. As I was mentioning, and again flows from the principle that since all those VC investors are coming in the capacity for purely financial investors, so you would see that their directors nominated are in the capacity for non-executive directors, right? Because executive directors are the ones who generally are at the running the show of the company, who are at the helm of the affairs, who will be conducting the day-to-day affairs of the company. So you would see the promoter directors being taking the charge of executive directors, but the sort of investor directors are non-executive directors. Now, obviously, there are certain statutory liabilities and obligations which sort of fall on the executive directors and not the non-executive directors, like the officers in default, for example, under Companies Act. Executive directors are kind of by de facto become officers in default, so which essentially means that for any default in terms of filings or any kind of compliance with the provisions of the Companies Act, there are implications on those executive directors or the officers in default, right, which do not naturally automatically fall on the non-executive directors. Correct. So that is something which the investor also bears in mind, and hence their directors you generally see are in the capacity of the non-executive directors. Having said that, these rights are not absolute or unconditional rights, correct? Because at the end of the day, investor is a third party and who is getting all those preferred rights in lieu of the investment which it is bringing in as equity capital, correct? But going forward, there may be change in the capital, there may be change in the dynamic, there may be change in the equations. And, it may so happen that the investor is stopped investing more in the company. There are, different sorts of investor, other third parties which have come into the cap table of the company, or for that matter, that investor has started disposing of his shareholding, and by which it has become it's now ends up holding a minority stake in the company. So what I'm trying to drive here is that these rights are no way, absolute or unconditional rights. So obviously, in light of what I said and what can happen going forward with the investor shareholding, the promoters and company do generally push back, saying that this kind of preferred rights should fall away once the investor's shareholding falls below a certain threshold, right? Again, there is no hard and fast rule. I mean, these are all very contractually agreed principles or contractually agreed terms, right? So for that matter, investor can still happen to have a right to appoint one director till the time it is holding one share, but you wouldn't usually find such construct to playing around in the VC ecosystem. So again, depending on the nature of the investment, stage of the investment, the dynamics between the investor and the company, this shareholding threshold gets fixed. But let's usually you would find, let's say 7% or a 5% as a certain usual standard threshold, below which the promoters in the company generally asks, or generally, sort of their pushback is that if the investor's shareholding falls below 5% or 7% or 3%, whatever the agreed construct is, they should stand to lose most of their key rights, including their board rights. Right? Because the rationale is that the investor clearly, I mean, if you start with let's having 20%, 15%, if it falls below 5%, 3%. So for whatever reason, the investor, does not have much skin in the game. So either it's not investing more money in the company. So obviously, it cannot ask for the same proportionate set of rights. or let's say investors started disposing of its shares in the company. So obviously the investors become a kind of a minority shareholder to that extent, and in all probability there will be other investors, bigger investors for which the company and the promoters have to accommodate. So that is the principle, that is the benchmark which the companies and the founders flow, so as to avoid this scenario wherein they have to extend each and every right to each and every investor who is coming on their cap table, because obviously, as you would understand, it will become a sort of a nightmare as terms of the administrative and the operational challenges are concerned. So that's about the board rights. Next is the shareholder rights. Investors holding, as I was saying, the investors in all likelihood generally stands to hold the preference shares of the CCPS. So as a shareholder, it has got certain rights. Under the Companies Act, obviously, there are certain rights which also can be contractually agreed over and above. One, as I have said, the voting right is the most important right for a shareholder. So if the investor holds equity shares, then no problem at all, because the Companies Act itself provides the voting rights for the equity shareholders, and that can be provided as a shareholding. But as I mentioned that, more often than not, you would see VC investors opting for a CCPS, compulsory convertible preference share, as opposed to an equity share, right? Because of certain preferential rights it provides vis-a-vis the equity shares. But having said that, as I was mentioning when I was discussing the instrument of CCPS, the voting rights attached to the CCPS can be sort of structured flexibly, or are more malleable when it comes to the private company, right? By which I mean that the voting rights, though the Companies Act provides very limited voting rights to preference shareholders, but if it's a private company, you can have a contractually agreeable voting rights attached to the preference shareholders as well. And generally, the way it happens, as I was saying, that investors take the voting rights on as if converted basis, right? That means they calculate the voting rights attached to the preference shares, assuming that they have been converted to equity shares, and they take those voting rights provided to those equity shares, whatever they hold. Right, so that's one. And again, as a shareholder, so whatever the statutory rights shareholder is supposed to get, the investor gets that. That means it has the right to receive the shareholder meeting notices, agendas, minutes, etc. Right. At times, again, just to avoid all those administrative challenges, if there are, you would see that there are multiple individual investors, or the angel investors, or retail investors on the cap table. Generally, the company and the promoters can ask for that, instead of sending and communicating each and every shareholder on a daily basis, they may ask for one representative of those angel investors who can come to the meeting, to whom the notices and the agendas can be sent, and whose vote will be constituted as a vote for all the angel investors as a block, right? So it kind of also helps in the smooth operation of the company, as opposed to having a very scattered and a fragmented voting from multiple of sort of small or angel investors who are holding a very minority shareholding. So again, that's a contractually agreed thing, but that's something which we have seen in this ecosystem. Okay, so now moving on from the equity shareholder, from the shareholder rights. Now moving on coming to the key information rights, right? Now, as an investor, as I was mentioning, there are certain checks and balances which, although since the investor is participating in the equity risk, it wants to provide certain necessary safeguards to ensure the company is going in the right track, or to have a kind of certain monitoring system for what all is happening in the company, and whether it does have an adverse impact on the investments, or just to have a periodical check on the different parameters of the company's business operations. Correct. So, because again, so just to put the underlying principle being that, an equity investor, as you would be aware, that is a kind of a minority shareholder, right? And that's why it's seeking for all these rights, because the underlying principle is that, promoters will be running the show of the company, correct? And so to have the promoters to run the show of the company, they need to have the control of the company. So that's why we'll see more often than not promoters having the majority shareholding of the company, correct? So that they can take decisions in a smooth manner, be it at the board meeting, be it a shareholders meeting, or otherwise. So not only do they have the majority shareholding in the company, so by same stretch of logic, they also have a majority representation on the board of directors of the company. Correct. So usually the board seats and the board construct is heavily skewed in favor of the promoters, right? So you will see probably an investor having a one nominee, but promoters having more than one nominees, two nominees, three nominees, etc. Because the reason being that promoters definitely would not want things to be stuck at the board meeting, because they are going to be sort of running the show of the company, right? So, and if things get stuck at the operational level, they really don't have any independence to run the company, because investors are merely putting in the money and in the capacity of financial investors. So from that perspective, since the investor is a minority shareholder and they are not in the know-how of the day-to-day affairs of the company, so these information rights become a crucial right for the investor, at least to know on a periodical basis what is happening vis-a-vis the different aspects of the company. Correct. So what are the key information rights which an investor generally seeks for? One, of course, is the financials of the company, be it the audited, yearly audited, or you would see if there is unaudited, you would see the monthly unaudited or the quarterly unaudited. Correct. Obviously, their investments, they have been made based on certain projections, estimates, costs based on the business proposition, and so the financials are a best, sort of reflection of what is happening in terms of the business of the company. Correct. So that's one. Second information right which becomes important is the business plan of the company. Sort of business plan is more so what the company intends to do over the next 6 months, 1 year, 2 year, 3 year, depending on the kind of the business plan which is being made and prepared by the promoters. It will give you essentially an idea about the projections, the estimates of the company, the cash flows, the projected expenses, the OPEX, CAPEX, etc., the growth plans, etc. So that also becomes important for the investor. Thirdly, obviously, by virtue of being a director, having a director seat, and being a shareholder, the minutes of the board and shareholder meetings are something which the company needs to provide to the investor on a periodic basis. MIS reports, the monthly information system reports, is something you would have seen recently. This is something every other investor seeks from the company and the founders on a periodic basis. That means on a monthly basis. MIS again, it kind of gives you the idea about the business of the company or the position of the company on a monthly basis, like what have been the performance of the company in terms of cash flow, expense, revenue on a monthly basis, whether it has been able to meet those monthly projections or monthly estimates. If it is not been, by what is the extent by which it is differing, performance, or probably a comparative performance vis-a-vis the last month or vis-a-vis last month for the previous year. So different sorts of aspects can be covered in the MIS reports. So that also becomes an important document to have a comparative understanding or an assessment of the position of the company on a month-by-month basis for an investor. Apart from that, again, there are certain key documents or key information. If the investor deems fit, then it can ask from the company and the promoters. Like one, of course, if there is any kind of material litigation which has been initiated by the company or against the company, if there is a kind of material settlement which is going to be done by the company. So that is, a matter which can be of concern for the investor. Because anyways, as I've seen, investor being in the capacity of financial investor. So anything which is being material or which has a material impact on the business operations, revenue, assets, position of the company, financials of the company, becomes a concern of the for the investor itself, right? Or anything which is happening to the promoters on a material basis scale, that also becomes a concern for the investors, right? So these are the key sets of information rights which you generally see an investor asking from the company and the founders. Lastly, as I mentioned, that again, these are the not absolute or unconditional rights. These again can be negotiated, what all the company and the founders are comfortable giving. Obviously, there will be certain very key material information rights which you would see a VC investor will not negotiate. They will be sacrosanct. But again, this can be negotiated, at what point those information rights should fall away or can fall away. As I was saying, again, a lot of rights are attached to the kind of shareholding, the kind of money which the investor is putting in at that point of time. It may so happen that going forward, when the company is growing bigger, when the company is in need of more funds, that investor kind of is not in a position to invest more funds in the company, thereby more investors coming into the cap table, thereby that investor's shareholding getting diluted, or that investor, sort of voluntarily transferring his shares, thereby having a more minimal shareholding. And at that, those are the thresholds, depending on how they are negotiated. The company and the promoters can generally push back that once your shareholding falls below a certain threshold, be it 5%, 3%, that means you don't have a kind of a material stake. You have become a kind of a minority shareholder, and so there is no reason why all those preferred rights should be extended to you. And it becomes important and crucial from a company and promoters perspective at times. Also, in light of the example I was giving, if there are more investors coming into the play who are in future rounds, who are bringing in funds at a higher valuation, who are bringing in more funds, who are having more important stakes, then the promoters and company can say, see, I am fine to extend these rights to a certain set of investors who are putting in this money, who are holding this per stake. But investors below a certain stake, naturally should those rights should fall away, because obviously they are not participating in the growth capital of the company in those future rounds. So these are all subject to commercial discussions, but these are generally certain principles of discussion which we would find across happening from the investor and the promoter side when these rights are being deliberated and negotiated, right? Next, one important corporate governance matter which I was mentioning, that is the affirmative vote matters of the reserve matters. Now, what are these as a concept? And again, since the rationale comes from the fact that the investor is a minority shareholder, right, and the promoters are running the show of the company, so you would generally not see them, having a kind of a unilateral say, be it at the board meeting or the shareholders meeting, right? You would not find a matter which can be unilaterally passed by the investors, be it at the board or the shareholders, because they hold a both minority position in both of these instances. However, having said that, again, to safeguard its rights, to protect its investment, and to ensure that because the investors also put in the money based on certain estimates and based on certain position of the company, right? So in order to protect his rights and investment, this again becomes a crucial minority shareholder right. Essentially, what the investor seeks is that, in terms of key matters or in terms of taking key decisions, like the decisions on the likes of whether the company, should go for a merger, demerger, asset sale, or go for a corporate restructuring altogether, which changes the very ethos and fabric of the company. That is a very key decision for a company. Or let's say the company is going for a new business vertical, wants to start a new business. Or let's say the company wants to, sort of raise funds, more equity funds, thereby diluting the investor's share capital, or thereby diluting the investor's rights, etc. If or for that matter, in certain crucial operational matters as well, right? So in terms of, let's say, borrowings of the company beyond a certain threshold, if the company intends to borrow, let's say, in addition to whatever is approved in the business plan, or which is of a very high amount, or it wants to let's say, engage into OPEX or a CAPEX beyond a certain threshold. So these are those key matters, where the investor would like to have a say on, and thereby this entire concept of reserve matters, the veto matters come into the play. So what the investor seeks is that, it identifies certain matters in the shareholders agreement or in the term sheet, and wherein it says that before the company or the founders taking any decision on those matters, either at the board level or the shareholders level, prior written consent of the investor would be required, right? Either at the board or the shareholders. Because essentially, again, this is all stemming from the fact that since investor holds a minority shareholding, the promoters will hold an overwhelmingly majority shareholding. It may be very likely that if the promoters tomorrow wants to go for a merger of the company, and let's say investor does not have these rights, the promoters will be in a position to go ahead and pass any resolutions to that effect, be it at the board meeting, be it the shareholders meeting, be it the ordinary resolution or the special resolution, as the case may be. Correct. So that's where the rationale of the investor comes into the play, because it's saying that, like I've participated in the equity capital, I've participated in the equity risks. So it's imperative that there is, before taking these decisions on these very important matters, which relate to either corporate restructuring, which relate to impact on my rights, either in terms of dilution of my share capital, shareholding, or modification of my rights, or for that matter, a few key operational matters, right? Like, borrowings beyond a certain threshold, taking OPEX or CAPEX beyond a certain threshold, which can kind of have some certain long-term ramifications on the business and operations of the company. The investor can seek this right as a veto right? Before taking the decision, you please come and take my consent. The idea again is, which the investor puts forth, is not to run the company. So that's why if you look at it, those list of affirmative vote matters or the reserve matters are at times very heavily negotiated and deliberated, because at times, and rightfully so, at times the promoters and the founders will say, if you kind of, are asking for an entire 30, 40 reserve matter items, it's very likely that a lot of matters will kind of overlap with the day-to-day operations of the company, right? That means, it's very likely that for the promoters to run the show on a lot of matters, they need to come to the investor to take his consent, right? So then, naturally, you can see a lot of pushback happening. If you see a lot of reserve matters overlapping with the day-to-day operation of the company, on those lines, you may see a lot of pushback happening from the promoters and the promoters, primarily on these lines, asking the investor to stop having the say on a day-to-day operational matters, right? So that again, this list is a subject matter of negotiation and commercial discussion. But the underlying principle is that, in order to protect its investment, in order to safeguard its key rights and interests, there will be a certain list of identified matters, primarily on the lines of corporate restructuring, matters, issuance of new securities, raising of new funds, matters relation to key operational matters on which the investor would generally like to have a consent right, and not only a mere voting right before the company takes decisions. Correct. Now, having said that, depending on how the negotiation and deliberations flow, and if the promoters feel that having such unconditional consent can and depending on how the reserve matters look like, if the promoters feel that there are certain operational matters on which the investors having such unconditional right can impede the smooth operations of the company, then at times you may see that the promoters can also ask for pushback for having the deemed consent provisions, because promoters generally can say that what if I have passed on this matter for investors' consent, but investor has not responded to me. He's just sitting on the matter. Clearly, he is not in an active role managing the company. He's more of a dormant role. He's more of a passive shareholder. But I am in the active role. Right? A promoter can have this valid concerns. I'm running the show here. So what if the investor does not show any response? But if I can't even take this, take any decision on this matter. Let's say I need a borrowing for the company. What if the investor does not consent it? But I'm in urgent need of capital. What happens then? So on those lines, the promoters at times can ask for deemed consent, on these lines that if the investor fails to respond within a certain timeline, be 7 days or 10 days, it can be said to be a deemed yes. And again, it's a very key right for an investor. And, such rights is attached to the kind of investment and the valuation of the investor is coming in. So according to the same principle applies for the other key governance related rights. So essentially, if the investor shareholding falls below a certain threshold, generally those rights can also follow. Right. Next is on the vesting and the termination of the employment. Now, what does it suggest? Essentially, so this kind of construct becomes important when you say more of an institutional investor on the likes of, let's say, Series A, VC investor at the time of Series A or thereafter, which that comes into the play, right? Now, what is vesting and how it is linked with the termination of employment thing? Just to give a broad overview, vesting in India is a notional concept, right? Now, why is it important and why do the generally investors look and ask for these rights? Because their rationale is that, since most of the VC investors come at a very early stage growth level of the company, right? They invest in the company where the sort of more so in the stages of the early growth where the company is just growing or kind of pre-product stage or it just started developing, etc. Correct. So it becomes so essentially, from the VC investor standpoint, making a bet on the company is kind of tantamount to making a bet on the promoters, right? Because for them, the company has not become profitable, right? The company is still in a stages of early growth. It's growing. It has, it is seen as a lot of potential, and they're actually looking at the potential of the company, which means they're looking at the potential of the founders. Because clearly, as you would be aware that any kind of startup or an early stage company or an early growth company definitely does not have the desirable numbers in terms of profitability, EBITDA, etc., to convince the investors to make a compelling case for the investors to why they should invest in the company. But what they do have, obviously, is the vision, is the credibility, the pedigree of the founders, is the founders' expertise, their experience, what they're bringing to the table, what their contributions would be, etc., etc. Right? So what I'm trying to say here is that for an equity investor, for a VC investor, a company is same as the founder or the founders who are running the show of the company. Correct. So that's why, from the investor standpoint, it becomes imperative that the founders continue to have sufficient skin in the game till the time investor is invested in the company. Correct. And how do they ensure that? Sort of how do they bind those promoters? How do they kind of make sure there are enough incentives, or rather there are enough disincentives? So as to ensure that the promoters have sufficient skin in the game, or to ensure that the promoters will devote their sufficient time and have sufficient commitment towards working towards the company's growth, development, business, etc. And that's where this entire concept of vesting and the how it is linked with the termination, etc., comes into the play. So as I was mentioning, vesting in India is a notional concept, because unlike US, because in India, when the promoters or the founders start a company, they're already subscribing to certain instruments which will be the equity shares of the company, right? So it's not like that you can really sort of because the shares are allotted upfront, right? So there is no, so unlike in US, the company can hold the shares in the form of treasury stock, etc., and then release to the promoters on a certain periodic basis. That is a very different construct in India, right? So that's why all this entire concept is notional has to be agreed contractually. Now, how does this work? Right, the shares are already allotted to the promoters. What the investor says is, once investor comes into the company, so for the next period of 4 to 5 years, they will be notionally restricted. Right? So they will be notionally the shares will be notionally restricted, contractually restricted, and they will be released on a notional basis contractually over the next 4 to 5 years on a periodic basis, and the periodic basis and in in equal installments, and the periodic basis may be monthly installments, quarterly installments, half yearly or yearly installments. So just to give an example, there can be a contract or there can be a clause on the lines of vesting saying that the let's say 100 shares are being held by the promoter, and the vesting clause can appear like this: 20% of promoter shares to be vested over the next 4 to 5 years on a yearly basis, equally on a yearly basis. So essentially that means that after every year, so 20 shares of those held by the promoters get notionally vested within the promoters, right? And after 5 years, the 100% shares get notionally vested with the promoters. So essentially, after 2 years, 40% of the shares get notionally vested with the promoters, 60% still remain unvested with the promoters. So these are all contractual notional concepts because, again, I'm reiterating, the promoters are already holding the shares, right, as far as the legal parlance is concerned. But contractually, we are creating these restrictions and the release, etc. And we are linking these two implications to what happens with the cessation of employment. Now, why are the investors doing that, and why is this construct is being generally deliberated? As I was saying, the underlying rationale being that they want to make sure that the promoters don't do anything rash, or for that matter, if they do anything rash or anything serious or anything grave, which is against the interest of the company, which has an adverse impact on the business operations, which has an adverse impact on the investors' investment. So there are sufficient disincentives for that, right? So that's why this entire notional restriction and binding are coming up. Now, what do I mean when I say, started doing certain rash or kind of, trying to safeguard, trying to put forth those apprehensions? So obviously, one will be the one set of apprehension, which the investors generally very worried about. That is for a cause, right? What if the promoter commits any cause event? Now, what is exactly cause? Now, in the parlance of this shareholders agreement, etc., cause generally includes very serious and grave offences. Like promoters committing any criminal act, or promoters getting any criminally charge sheeted, correct? Or promoters committing any very heinous offences like fraud or willful misconduct, which has got far-reaching ramifications or repercussions vis-a-vis the business of the company, and also on a reputational scale, right? Because no investor would like to stick in the company, because for an investor, it's a huge loss, right? Because investor is not running the show of the company. It's entirely relying on the credibilities, on the expertise of the promoters. So tomorrow, if the promoters gets entangled into a criminal act or entangled in a fraudulent activity, it's not only the business operations get impacted, the entire reputation of all the stakeholders of the company gets impacted, right? So I mean, the entire investment, you can say, goes for a toss in such an early stage company, because nobody will put money in the company. There is nobody else to run the company. Right? So obviously, these have very serious implications, and hence the treatment or the implications also be treated with such serious proportion, correct? And that's why this entire vesting construct comes into the play. So moving forward, as the next step for the vesting, where we are saying the contractually restricted and contractually released. So let's say on the occurrence of the cause event, which I just mentioned, like in the occurrence of such serious and grave events, it is generally contractually agreed that whatever is invested and the unvested shares. So let's say as I was mentioning, from the date of investment, let's say the promoter shares are to be vested equally, over a period of 5 years, 20% yearly over a period of 5 years. So let's say the promoter commits fraud, after 2 years. So what the disincentive provides, or what the deterrence provides, for commission of such serious act, is that whatever has been released and unreleased, that means whatever the shares have been vested and unvested, they needs to be transferred on cause at a nominal value, correct? And who needs to be transferred it? Either they can get transferred to the ESOP pool so as to provide sufficient incentives to the employees of the company, or they can get transferred to the other co-founders, to provide incentives to them, or they can get transferred to any incoming co-founder, because that clearly, since that founder has committed such serious offense and such cause event, so obviously there certain implications will flow. Once one, of course, he or she will lose the employment, he or she will lose the directorship, and then clearly, it may so happen that the board can require a new incoming founder to come and take the reins of the company. Correct. So, at times the transfer can also happen to the incoming founder of the company. So the point here is that, and an occurrence of different events, you will generally see under this construct having different treatment or different implications. Like one, for example, on the occurrence of events such as cause, which is such a serious event, you see that the treatment and the implications are also very serious. Right, because one, not only the investors are asking that, let's say, because see, contractually what has been agreed is that, let's say, after 2 years 40% gets vested, right? Only 60% is unvested. But since it's such a serious event, the investor can ask for that not only your 60%, because not only the unvested shares get forfeited, your vested shares can also get forfeited because it's such a serious event. So the repercussion also is so serious. So accordingly, for a occurrence of a cause event, you would more often than not see that not only the unreleased shares, even the released shares get transferred at that to a nominal value, right? At that to a par value, which the investor generally asks for, and they get generally transferred to the other employees of the founders to incentivize them to work. Correct. That's one construct we'll generally find. The other construct is that what happens, let's say the promoter has not committed such serious wrongdoing, on the likes of cause. Let's say the promoter has not criminally charge sheeted, he has not committed any fraud or willful misconduct, etc. But it's a one fine day, the promoter has just stopped coming to the office. Correct. So there are certain instances also which are carved out. What can also happen if such event happens, terminating to a resignation or a breach of employment, but which are not very serious. So like termination happening or resignation happening, but for reasons without cause. Correct. So there may be instances like that. Like one, for example, because as I was mentioning, the investors are clearly relying on promoters' pedigree and capabilities, right? And their commitment and devotion. So if the promoter stopped coming to office, so the investor is left stranded high and dry. So that is definitely not a desirable option for an investor. Or for that matter, a promoter is not performing to his ability, right? Depending based on whatever promises he has made, he has become slack. He has, for whatever reason, he is not performing to the ability of his capabilities, right? So at that time, also if the board is quite broad based, if you have got multiple investors sitting on the board, then that the majority of the board can also take a call to sort of terminate the promoter. So what I'm saying is that one, of course, is a set of very serious and grave offenses which are akin to a cause events and which have got very serious implications. Apart from that, there may be also termination or breaches or resignations, not on those serious lines, but which can have an adverse impact on the day-to-day running of the company. So on the occurrence of such events, then there is a different set of treatment also, which is deliberated, negotiated. So let's say the promoter stop coming to the company, which can be construed as a termination without cause. Then what the investors can generally ask for, okay, fine. Let's say promoter stop coming to the company after a period of 2 years. So that means 40% of the shares have been vested, but 60% have been unvested. Then the investor can say it's fine. Then you can stay with the vested shares, but whatever is the unvested shares, that is a notionally unvested shares which have been contractually agreed, that should get transferred again to either to an ESOP pool or to the remaining co-founder or to an incoming founder. And at what value, obviously the promoter can push back saying that, okay, boss, you cannot, sort of have such harsh treatment on me because I have not done any wrongdoing as such. There may be other reasons why I do not wish to be associated with this company anymore. And hence, even if you're transferring those unvested shares, there has to be at least at the fair market value and not at the par value or the nominal value. So yeah, so that's another construct which also gets deliberated and negotiated for termination without cause, and what happens to the shares of the vested, unvested when there are terminations on different accounts. Lastly, there is also construct on the lines of, it can be a scenario, what happens in the case of a death or permanent disability, which is again a very hypothetical exigency, but generally it provides for an accelerated vesting, which can happen to the legal heirs of the promoters. When by accelerated vesting, I mean because this is something which is completely beyond the control of those promoters. And so let's say after 2 years, such exigency happens, the investors generally agree that you do not need to stick around, because clearly on such an event, the promoters will not be in a position to work towards the company. So whatever let's after 2 years such an event happens. So by accelerated vesting, it essentially means that those 60%, 40% is already vested, but the 60% which is unvested gets vested on an accelerated basis. That means the entire 100% would vest after 2 years if God forbid such event occurs, right? So that's how generally the investors try to seek and negotiate this entire vesting and linking to the employment and the termination of different scenarios thereunder. Now moving on, of course, there are certain construct this is more so important and relevant from a subscription agreement point of view, which I was mentioning that there are certain terms and conditions which are linked to the investment by an investor. You would find a broader mention of them in the term sheet, but you would find them much more detailed out in the share subscription agreement. Correct. And what are these? Firstly, it comes under representations and warranties. Now, what are representations and warranties? Now, these are the standard. These are the sets of statements which an investor seeks from a company and the promoter, which they want the company and the promoter to make regarding the position of the company on all various aspects, and to warrant. And by warrant, I mean that, and to also make the statement that all these positions, all the statements which they're making regarding the various positions of the company stand true, valid, and correct in all aspects. Correct. Now, what do I mean by that, and why is it important? Because this becomes important from an equity investor point of view, because one, of course, a VC or an institutional investor is not a promoter, is not an existing shareholder in the company, right? It is merely a third-party investor, and which is coming into then investing in the company based on certain assumptions and based on certain promises and based on certain statements made by the company and the founders, right? Because whatever the information regarding its financials, regarding its business, regarding its revenue, regarding its compliance with laws, regarding its intellectual property and other aspects it stands to make, they are being made by the founders and the company. Obviously, because the investor is not in a position to know what is happening in the company. Correct. So naturally, the investor wants to have some comfort that whatever and that's how, based on whatever statements he has made, like this is the financial, this is the revenue of the company, there are so many shareholders, this is what the company does as a business, these are all the licenses taken by the company, etc., etc., etc. The investor sort of agreed to make the investment and also kind of sort of reached a certain valuation. Correct. Now, what if tomorrow the investor finds out that those position of the company is actually not what the company and the founders have told me that, right? Because let's say the company and the founders have told the investor, there are no proceedings, there are no legal proceedings, there are no third-party claims against the company. But once it makes the investment and tomorrow it finds out there has already been a pending claim prior to the investment made in the company, right? And there is a very material claim by a third party, which clearly the investor, the founders and the company have not disclosed or kind of not sounded them upfront, or suppressed this information. So in this context, this set of rights becomes important, and that's where the representations and warranties. So by representation, that means the company and the founders are going to make statements regarding the position of the company. Like one of the representations I have said is that there are no litigation or claims against the company, or the shares which are being issued by the company are kind of valid. They don't have any encumbrance. They are all valid under applicable laws. They have been duly issued, or the company is duly incorporated. So things like that. So these are the representations which the company and the founders need to make on all the aspects of business operations. And the warranties is that whatever statements they're making, they're also ensuring and they're also promising that they stand true and correct in all aspects. Right? So the key representation of warranties which generally an equity investor takes is that the founders and the company have the necessary power, capacity, and authority to deliver their promises, to perform the subject matter of the agreement. These shares which are being issued to the investors, they're validly issued and they're without encumbrances. There are certain business operation related representation warranties which are taken, like the company has the valid licenses, there are the financials are accurate, there are no litigation claims, it has all the necessary permits, there is no infringement of third-party intellectual property, etc., etc. Correct. Now, what happens, as I said that those representations go wrong, or there's a misrepresentation, which the investor finds out later, right? Or whatever, if it is said that the shares are validly issued and they find out on the title is defective in those shares, then what is the remedy of those investors, right? The remedy contractually comes in the form of indemnity, right? Now, what is indemnity? Indemnity is a mode of promise whereby the founders and the company promise to compensate the investor on such representation going wrong. That means on such, if there is any misrepresentation to that effect on whatever the statements they have made on different positions of the company, if there is a breach of obligations, and of course, if there is any sort of key events like fraud, etc. So on all those accounts, and if there is a loss suffered by the investor, so then generally the founders of the company agree to indemnify those investors. Obviously, coming from the promoter and the founder standpoint, for promoter and the company standpoint, they would not like such indemnity obligation because it's a liability, right, for the promoters of the company. They would not like it to be uncapped, or they would not like it to be perpetual or open-ended in nature, and hence they generally kind of push back and negotiate for certain qualifiers and limitations to be brought in. Like the quantum cannot be open-ended, so it has to be it has to be capped to the investment amount what the investor is putting in. There cannot be perpetual indemnity, and hence generally it is negotiated that for the business operation related reps and warranties, if they go wrong, there has to be 3 years. For tax related representative warranties, it has to be 7 years. And since and also there are certain other limitations, like in the early stage companies or in the companies in the very early growth stages, promoters generally say that specifically if they're individual promoters, they generally say that they won't have that net worth or that asset or the liquidity to indemnify. So they would try to seek out, carving out or kind of limiting their, personal assets thing, and hence not invoking a promoter's personal assets also can become an agreeable condition. Obviously, there are certain exceptions. Obviously, if the company or the promoter is committed any fraud, which kind of goes to the very root of the transaction, or let's say if there is any fundamental misrepresentation, like the shares which have been issued to the investors turn out to be defective in title. So that again, which goes to the very fundamental aspect of the transaction, root of the transaction, there can be exceptions to those indemnity. Now these are again what are the terms and conditions generally attached for an investment by an investor. Having said that, now another kind of obligation or a term condition which becomes important from an investor and a promoter standpoint is the non-compete and the non-solicitation. This again links back to the kind of construct which I was discussing, that when an investor comes and invests in the company, it tries to make sure that promoter devotes sufficient time, capital, efforts, energy, etc. towards this business, towards the growth and development of this company's business operations. So that's why it becomes important to have this kind of restrictions and obligations on the promoters. One of them, of course, the promoters agree that they will not engage in any kind of competing business. They will not solicit any kind of employees, customers of this company and try to divert the business into any other entity. So, till the time, the promoters is employed in the company, or till the time promoter holds any shares in the company, and the cooling off period post that. Generally, these are the standard covenants which are being sought by the investor, that the promoter will not engage in any manner, because again, the underlying idea is that he will devote all his time, attention, efforts, etc. towards this company. Okay. What are the other economic rights which are being also availed by the investor? One of them is the liquidation preference. What is liquidation preference? You could see that, it generally would come in a term sheet or a shareholders agreement, that at the time of distribution of proceeds by a company, generally investors, since they're putting in the equity capital, they kind of seek to have some sort of preference or some sort of kind of a minimum assured kind of return on those terms. It can flow in the form of 2-3 different ways. Now, on what all events this gets triggered? This usually get triggered when the company's entire structure is being changed, right? So how it can be changed? One, of course, if the company is going for a winding up or liquidation. Secondly, that if the company is having its merger, demerger, or different forms of restructuring, like there's a change of control happening, acquisition happening, business sale happening, etc. Now, what exactly the investor is asking for, right? So what the investor is asking is that, on the occurrence of any of this event, which is the liquidation event, that there has to be a payment when the company is distributing those liquidation proceeds. So investor is asking kind of, rights on two fronts. So one, the amount of proceeds which an investor is entitled to get, and that what it generally seeks is that, higher of either my 1x of the investment amount, so that is a minimum guaranteed of at least the investment amount which I'm putting in, or the pro rata proceeds. So pro rata proceeds which will be higher than the 1x investment in the case, obviously, the company is doing well or doing better, than the valuation at which the investor has come in. Then obviously the investors, pro rata will be higher than the 1x investment it has brought into it. And so if the company is doing well, all the liquidation proceeds gets divided pro rata. So it's all hunky-dory. So everybody stands to benefit. However, this liquidation preference will specifically or practicalities will get triggered if there's a distress sale happening, or let's say if the company has not done well, right? Because if the company has done well, then the pro rata, gives sufficient proceeds to every stakeholder, be it the promoter or the investor, right? So then there is no waterfall, or there is no preference as such. But if the company has not done well, right? So, and if there is a distress sale happening or distress restructuring happening, then that's where this entire the 1x will get triggered, and the preference will get also triggered, right? Because then the 1x essentially ensures in terms of the investor that it at least stands to get paid at least the investment amount, whatever is put the money. That's one. And the second preferred right which the investor seeks is that in that case I'll have a waterfall, right? And then I'll have a preferential treatment in priority to the other shareholders, including the promoters. That means that if the company has not done well, not only I get 1x, I'll get 1x in priority to the proceeds which you're distributing to the other shareholders. Firstly, I get 1x, or if there is insufficient proceeds, so whatever proceeds are there, you give me to make it up for the 1x, and then whatever is remaining, you distribute to the other shareholders. So this is generally a usual construct which is now being agreed deliberately in the liquidation preference clause. Correct. Higher of 1x or pro rata has now become more or less an agreeable construct. Previously, a few years back, investors were seeking probably a much more onerous or slightly more draconian liquidation preference thing. It can be of 2x, 1.5x. But as and when the kind of ecosystem was also getting evolved and matured, and the dynamics are constantly changing between the promoters and investors, 1x or the pro rata, the higher of, has become more of an usual construct as far as liquidation preference is concerned. Next is the ESOP. ESOP is more of moral. You would have seen a mention in the term sheet. It's more of a notional reservation before the investor comes in, so that it understands where it's where it stands in the cap table in the company. And the idea is to at least have this notional reservation of some equity prior to the investor coming in, so that it does not stand further diluted once it comes into the company. So generally, ESOP you would find in a term sheet that is mostly a notional reservation, right? And the company can do it by taking a board resolution. And once the investor comes in, generally the ESOP gets implemented and formulated by passing an ESOP scheme and whatever the necessary provisions under the Companies Act are, by passing the necessary board and the shareholder resolutions. Okay. Next, moving on is on the certain transfer related rights or the share related rights which the investor generally seeks in a term sheet and correspondingly in a shareholders agreement. Right. One of them is the preemptive right. Right. So preemptive right, as you would have found out, it's a right essentially to subscribe in the next round. It's a right given to the investor so that it can maintain its pro rata shareholding, maintain its current shareholding in the next round of funding. So that's essentially a preemptive right. What it says is that in the next round of equity-related funding or equity-linked funding, the investor will have a right to put in that amount of capital to maintain its present shareholding. Correct. So that's a preemptive right which an investor seeks for. Nextly is the anti-dilution protection. Anti-dilution protection is something which the investor seeks to maintain, to maintain its interests or its rights against a down round issuance. And what do I mean by a down round issuance? So let's say, investor comes at a valuation of, let's say, where the share price was 100 rupees, correct? But let's say going forward, the company is not doing well and the company is again in need of funds. And since it's not doing well, its valuation has come down. And the only interest in the market which is getting from prospective investors is, let's say, 80 rupees per share, right? But however, the company has to kind of, raise funds to keep itself afloat. Now, what happens? Now, then the equity investor asks that in such a scenario, since you're kind of going for a future round, and that obviously the expectation why the investor comes into the company is the company should do well or expected to do well, and the valuation goes high, and the investor gets a financial return because it's a financial investor. It's coming into the company to reap its financial benefits or returns, right? But here, since it's not hunky-dory and the company is not doing well, so at least in terms of contractual protection, the investor seeks for this anti-dilution protection right, by which it says that if the company goes for a future round at a valuation lower than at which I came in, I should be entitled to more shares, right? Right, because because there should be some protection because I have paid at a higher valuation, but clearly you have not done well, and you are now raising at a lower valuation. So I should also be able to get that benefits of the queue raising the funds from at a lower valuation. Now, there are different modes of having this anti-dilution protection. I'll briefly touch upon those modes. One can be through a full ratchet. Now, what is a full ratchet? As I was mentioning, let's say the investors come at a price of 100 rupees. The next round, the company is raising the funding at a price of 80 rupees, right? So essentially, the investor is now entitled to receive more shares. How you arrive at the quantum of how many shares the investor is entitled to under the full ratchet? You have to assume that the investor had also come at 80 rupees, and according to the entire investment amount of the investor, gets divided by 80, and whatever the number of shares get arrived, and whatever the number of shares which investor currently holds, the delta is something which the investor is entitled to have as additional shares, right? Under the full ratchet thing. So essentially, at whatever the down is happening, the investor gets full benefit of the down, and according to the number of additional shares are being calculated. Now, either as a mechanism on how those additional shares can be given by the company, either you give those, and obviously this has to be at a nominal value. The investor is not going to pay for that because it's a mode of a protection for the down which the investor is seeking. Now, either the company can issue equity shares at nominal value, or if it is holding CCPS, it can also change the conversion ratio so as to entitle them to receive more equity shares as and when they convert those CCPS, right? So that's a full ratchet protection. There's another way of protection which is widely used is the broad-based weighted average. What it talks about is that it is slightly as the name suggests, you do not automatically entitled to have the sort of benefit at the next round valuation. But again, coming back to our example, let's say the investor has come at 100 rupees per share, and the next round is happening at 80 rupees per share. Obviously, the investor will not be able to get the benefit of 80 rupees per share, but a more of a weighted average, of the existing share capital and the next round will be calculated, right? So, and accordingly, somewhere between the 100 and the 80, the share price will be arrived at, and then the investor's investment will be pegged at that weighted average share price, and accordingly, the delta amount of shares will be calculated. So either he will get the more equity shares, or he will conversion ratio gets adjusted accordingly. Right. So previously, again, full ratchet was something, obviously it's more beneficial for investors, because by full ratchet it stands to gain more number of shares. But off late, and as on today's day and times, broad-based is something which is mostly used in the VC deals, and which has become more of an agreeable construct between the investors and the promoters. Correct. Nextly, coming to the certain transfer restrictions and the transferability rights of the investors regarding the shares, right? And by transfer restriction and everything, I mean what are the restrictions attached to the shares, either the promoters, either of the investors, and so on. Now, again, first important right here is the promoters lock-in. As I was mentioning, sort of investors coming into the company is also reflective of the fact they want the promoters to stay in the company, or to have the skin in the game, till the time they stay invested. So that's why one important factor is that the promoters should not have the ability to go ahead and dispose and transfer their shares to whoever they like, and that's why there's a categorical lock-in of the promoters' shares. That means the promoters are not entitled to transfer their shares to any party without the investor's consent, and that's what the promoters lock-in suggests. Obviously, there can be exceptions for if the promoter wants to transfer some shares to his relatives or to his affiliates for tax or estate planning purposes, right? So some exceptions can be carved out accordingly. So that's one. Second important kind of right for the transfer thing which comes into the play is the right of first refusal and right of first offer. What it suggests is that for a promoter to transfer any shares, right? So the investor says that okay, fine, if you want to transfer shares, you transfer shares, but before that you have to give the right to me to buy those shares out. If I have the appetite and the liquidity. Now there are two ways why this investor sort of seeks this right. One is right of first refusal. What is right of first refusal? Under this right of first refusal or ROFR, basically the promoter has to, wants to sell the shares. It first has to find a third party purchaser who is willing to buy its shares. It has to get a price which the third party is willing to quote for those shares. And once it gets the price, the promoter comes back to the investor and it will kind of, offer to the investor, okay, fine, listen, I have, this third party is willing to give me this price for these many shares. So now you tell me whether you're willing to buy it or not. So investor generally gets the right to match the offer or to refuse the offer, and hence the term ROFR, right of first refusal. If it matches the offer, then the investor can buy those shares at that price. If it refuses the offer, then the promoter gets to sell those shares at the quoted price at whichever third-party quotes, but not at a price below that. Right? So that's the ROFO. The other way the investor can seek this right is ROFO, or the right of first offer. So what does that mean? Which essentially means that promoter, before he transfers his shares, it comes to the investor. It does not necessarily need to go to the third party then. It can come to the investor. It can ask the investor, okay, fine, listen, I want to sell these shares. You tell me, you quote me a price at which you are willing to buy my shares out. So if the investor so desires, then it can quote a price. Okay, listen, I'm willing to give so much amount for these shares. Or it can either say, no, I don't want to buy your shares. So if it says, I don't want to buy your shares, obviously the promoter can then reach out to any third party and sell those shares. But if the investor quotes a price for those shares, then either the promoter sells those shares to the investor at the quoted price, or if it finds a third party, then I need to sell the price at a higher price at what it has been quoted by the investors, right? Now, obviously, as you can see that the ROFO is more preferred for the investors, because then the price discovery thing, what is the price, what is the proportionate, what is the market price for these shares, which is willing to give a third, which is willing to be given by a third party. That exercise does not need to be undertaken by an investor, because under ROFO, the onus is on the founders to find a third party and get a price quote and then come to the investors to match the offer. And ROFO is something which will be less preferred for the investors. So depending on the negotiations, again, the stage of the transaction, either the ROFO or the ROFO is being availed by the investors. Apart from that, there is a tag-along, sort of right, which has been generally being sought by the investors. What is tag-along? Tag-along is something which the investor says that, for the promoters, if they want to sell the shares, again, the rationale being that they are in the company because promoters are invested in the company. If the promoters start leaving the company or start disposing the shares, that means it shows that they do not want to have the skin in the game in the company anymore. So then the underlying principle is that the investors are also saying that, fine, if you want to exit from the company, then I should also have a right of proportionate exit along with you, when you are making that exit from the company. And that's why the tag along, right? So the investor seeks that I should have the right to tag along with you when you are making an exit from the company. Right. And so that's why that's a tag along thing. So if the promoter is selling his shares, any of his shares to a third party, the investors can tag along pro rata to his shareholding and also make a partial exit along with the promoter. However, obviously, if the promoter is selling majority of the shareholding, by which the control of the company changes, then obviously it's a fundamental change in the position of the company, because then the promoters are not in control of the company, the promoters are not in the decision-making ability of the company, and hence the investor can ask that, in such a case, I should have the ability to make 100% exit of the company. Because for me, again, the company is as good as the promoters. If the promoters are not promoters anymore, or the promoters do not have the control anymore, I should have the right to make complete exit. So there's a tag along. Similarly, at times, if the founders have higher bargaining power, they can also ask ROFO, the right of first offer, for any transfer by investors, essentially saying that, again, it depends on a stage to stage and how the transaction is shaping up. They can also ask that, for the investors, if they are moving away from the company, the founders can say that, before you bring any kind of third party on the table and on the cap table of the company, you come to me, I'll quote a price. If you're willing to sell me, you can sell it to me. I can buy that. So, and if I have that appetite, then I'll buy you out. Anyways, investors getting exit, and then that way founder is also kind of restricting from any third party to come on the cap table. So that's one. And other than that, investors generally have a free right to transfer, except of course to a competitor, which for obvious reasons, no shareholder generally has a right to transfer to a competitor except in certain circumstances. Apart from that, there are certain, again, next is the exit rights for a financial investor or for a VC investor in the company, and why are they important? Again, VC investors, since it is in the nature of the financial investor, would have a fixed lifespan of that vehicle, right? Any VC investor kind of would you see mostly structured in the nature of the fund, right? A fund, as you know, is a kind of special purpose vehicle with having a fixed lifespan. That means it also is accountable to its contributors or to its investors, whoever has put in money in the fund or the financial investor. So accordingly, sort of kind of having a certain visibility or timeline, or having some certainty in relation to the exit becomes crucial from a financial investor standpoint, right? But having said that, and that's why these exit rights come into the play, right? By which they kind of ask that, for the company and the promoters to provide these financial investors an exit within a certain timelines, right? But having said that, obviously, sort of as we understand that having a sacrosanct or having a kind of binding exit obligation may not also work, because the exit is something which is beyond the control of the promoters and the company. could be in a lot of cases, because how can the exit be structured? How can the exit be provided to the financial investor? It can be of few different mechanisms. One of them, of course, is an IPO or an initial public offer. But IPO, as we know, is dependent on so many contingencies. Like the company has to do well, it has to be profitable. Not only that, the market conditions have to be conducive. There has to be enough interest garnered by the prospective investors, so on and so forth. Right. Apart from the IPO, what all other exit can be contemplated? Of course, one is buyback by the company. But again, company buyback is also subject to a lot of statutory conditions. What all reserves can be used for the buyback? What all percentage of company can do for a buyback? And it may so happen that buyback is not possible. The other will be the third-party sale. Basically, finding a third-party purchaser, being the nature of the financial investor or strategic investor, and trying to give an exit to the investor. Right, so these are the 3-4 mechanisms by which an exit can be structured. But as you see, they are also beyond the control of the company and the promoters. And that's why you generally see the obligation is more on the nature of structured in the nature of a best effort basis and not in the nature of a binding obligations. The timeline is usually kept from the period of 5 to 7 years, because that is the timeline which generally company and the founders ask for to sort of, have this timeline to have enough growth in the company to reach that valuation by which, they can kind of figure out a more viable mode of exit, either in the form of IPO or taking another strategic or financial investor on board. Correct? At times, you would see a promoter put option. That means that investor having having a right after a certain timeline, that is after an expiry of let's say 5 years, where it can ask the promoters to buy the shares from them. But it is more of a kind of a personal obligation on the promoters, where the promoters become personally obligated and liable. And that's why in these VC transactions, you would seldom see that options, right? So that's how we will see mostly, IPO or third-party sale or strategic sale being structured as a exit rights. Now, there is another important right here, and which comes as a last resort right, and it is called the drag along, right? And what it means. It means that, as I was saying, as an investor is a kind of a financial investor, it needs to have a certain timeline for exit. And that's why these exit rights are contemplated. Investor generally has a free transferability right to make an exit from the company at any point of time. He finds a purchaser, so on and so forth. But what if, let's say, the company has not done well, right? And drag will only become applicable, when the company is not doing well. Because if the company has done well, then investor will get exit in some manner or the other, right? It will itself get a third-party purchaser who is interested to have a stake in the company, or the company and the promoters will get a purchaser or will get some mode of exit or the other to sort of provide this avenue to the investor. But what if the company has not done well? It has kind of moved, the business has gone southwards, and the investor needs to exit. Right? It clearly is not being able to find a buyer. So that's where the drag along gets triggered for the investor, by which the investor says, okay, listen, like clearly, company is not doing well. You have not been able to give me an exit. However, let's say, but I have to make a move, right? I have to make an exit by hook or by crook, because again, a financial investor has a certain limited lifespan. So let's say, then the investor says, let's say I find a buyer, but that buyer is someone, and in all probabilities at that point of time, a buyer, if it at all the investor finds a buyer, that buyer will be more interested in running the company. By which I mean that, it will so happen that, that third-party prospective buyer which the investor finds is just not willing to buy investor stake. The investor will be holding, let's say, 15%, 20%. But the third-party buyer, if the company is not doing well, clearly no financial investor probably would be interested in buying the stakes. So at those times, in all likelihood, if at all an investor finds a buyer, it will be more on the likes of a strategic investor. And by strategic investor means that, that investor who is keen to run this company, take over the company, take over the management operations business of the company, and run in its own accord. So that means it's very likely that that third-party prospective investor will be a competitor, will be having business in the same sector, same segment, same industry, etc. So at that point of time, so that's how the drag is generally constructed, and the drag generally plays out. The investor says that, clearly the company is not doing well, and I need to make an exit. So, and that's why after the expiry of that exit period, or whatever the 5, 6, 7 period, whatever is contractually agreed, and that's a reasonable timeline with which the company can be expected to grow. However, unfortunately, it has not grown. So then the investor says that, fine, I find a third-party purchaser. But if the third-party purchaser is such that is just not willing to take my shares, is willing to take much more shareholding than mine. Right? Because if a third-party purchaser at that point of time is a strategic purchaser as a competitor, it would definitely want to have 100% of the company or more than 75% of the company to run the company. So by drag along right, the investor seeks a right by which it can then ask the other shareholders, including the promoters, to sell their shares along with him to the third-party purchaser. Essentially, it has the right to drag along the other shareholders for the purpose to effectuate its exit. So hence, drag along as an exit right is a last resort right. It is being generally sought by the investors. If for any reason exit cannot be provided to the investors within the period of the exit period, that is a 5 to 7 years. So apart from that, there are other certain standard clauses which flow under the shareholders agreement, like the event of default, which generally are limited to any kind of material breach of obligations or any serious or grave offenses like the fraud, etc., or if the employee is terminated for cause. And why is it important? It's important because there are certain commercial consequences which flow from the EOD. So the underlying rationale for this EOD is that the investor generally says that if the promoter has done something which is very materially wrong, or right, which is very fundamentally wrong, so then there's clearly a sort of breach of fundamental trust. Then the investor does not want to stay around in the company. So that's how the consequences are structured. If such an event happens, the investor gets the right to make an exit at that very point of time in the company. Essentially, the investor wants to have an accelerated exit options. That means it can also have a drag, because one of the exit options, as I mentioned a while ago, is a drag, right? Drag otherwise scenario, it only gets triggered after the exit timeline gets expired. But again, on the occurrence of certain grave acts, the investor can ask that the drag should also get triggered at that point of time. So yeah. So that's how the consequences generally flows. They accelerated exit options, which also gives right to investor to sell to a competitor at that point of time, if at all an EOD happens. And yeah, so that more or less sums up the things. And that's all about the term sheet and the investment agreement, which you have generally found, or which you generally come across, which will come across all these important concepts and the construct and how they're deliberated, discussed, negotiated between the parties. I'll probably take just 5 minutes to quickly refer to the equity dilution and the cap table, which how it generally looks like. Right. As the last segment, it's just a simple illustration of a cap table. If you have come across, it's in a term sheet stage or in a post term sheet stage, where there's a cap tables are being shared by the company or by the investors. So if you look at it, the cap table right now looks into two categories. One is the pre-raising cap table and one is the post-raise cap table. As you see, the pre-raise cap table is only the promoters holding. You would mention, as I was mentioning about the ESOP thing, the investor would generally ask for a creation of a notional pool of ESOP, so that that pool is created pre the investor coming in, so that investor does not get diluted further once it comes in ESOP. Right. So this is how the general pre-raise cap table looks like. And I've given some illustrations. Let's assuming the investment amount is 3 crores and assuming it is happening at a pre-money valuation of 15 crores. Right. So you get the post-angel investment valuation. That is the pre-money valuation plus the investment amount. That will give you the post-investment valuation. And you can get the ownership by sort of 3 crores by 18 crores. You will get the ownership, and accordingly you can.
Mr. Souvik, it's not coming in the sharing screen.
It's not.
Excel sheet is not coming.
Okay. 1 second. Let me share. One second. Is it coming now? Is it coming now? Okay. Okay. So as I was mentioning, so the cap table, I have tried to sort of put forth an illustration of one, of course, is the pre-raise cap table, and the next is the post-raise cap table. I'll just quickly browse through the cap table to explain. So the pre-raise cap table is kind of depicts more from the point of view, and you would see this cap table become relevant as and when the term sheet is getting drafted, or as and when the definitive agreements are getting drafted. So pre-raise cap table is something which kind of depicts the capitalization structure of the company before the investor comes in. So as you see, it kind of will reflect the shareholding of the promoters which are in the company. And as I was mentioning, that in the ESOP thing, the investor can generally ask for an ESOP pool to be created in the term sheet, which is again a notional pool. And that's the ESOP you see is more of a notional pool here, but it's important to get reflected in the cap table, because so as to investor knows that before it comes in, what is the notional cap table structure and what is the ESOP allocated for that, so that investor does not get further diluted once it comes to the cap table due to ESOP. Right, so this is how the pre-raise cap table looks like. And I've given some simple illustrations, like let's say the investment amount is 3 crores, the pre-money valuation is 15 crores, then the post-money valuation becomes the pre-money plus the investment amount, that is 18 crores. Ownership becomes the investment amount by the post-money valuation, right? C11 by C13. That will give the investor the ownership interest. The price per share again, C12, that is the pre-money valuation by the total amount of the shares, which will give you the price per share. Just to bear in mind here, we have to kind of also calculate or take into factor into account the ESOP, though it is notional, because because even the investor shareholding is also calculated on a fully diluted basis, assuming the ESOP is also been factored in, right? Because that's the point I was trying to make. Because if you do not factor in ESOP, then essentially, investor shareholding will further get diluted once the ESOP, sort of its pool is created. And that is generally not what the investor is looking at when it is fixing up the broad commercial terms before its investment is coming, right? So that's why your price per share will also factor in the notional ESOP pool. Now coming to the post-raise cap table, post-raise, obviously the investors' investment amount will get reflected. So here the promoters' shares still remain the same, because it's a primary investment in the company. The promoters are not transferring the shares. However, obviously, since the investors are coming to the company, the promoter shareholding percentage obviously will change. The ESOP also shares gets reflected in the same manner. The ESOP percentage holding also gets changed, right? Again, the way if you have looked at if you have come across in the term sheet, you will find that mostly the investors take a nominal amount of equity shares so as to retain their equity shareholder rights, be in terms of voting, etc., and they take majority in the nature of the CCPS, right? So we have assumed that let's say the CCPS will convert into shares into 1:1, and hence you will find this total number of equity shares in a fully diluted basis. A fully diluted basis is that's why the relevance of the term, because fully diluted basis, as the name suggests, calculates assuming they have been converted into equity shares. So all of the instruments, be it in convertible or in whatever manner, they have been converted into equity shares, and that's the calculation happening. So that's why the ESOP, though it is notional, they have converted into equity shares. These CCPS have converted into equity shares. For the purpose of illustration, I've taken is to 1:1. This is coming to the total cap table. Accordingly, you can calculate the percentage, right? So this is more or less, the illustration how the cap table looks like: the pre-fund cap table, pre-raise cap table, and the pre-money cap table and the post-money cap table in the equity transaction, the VC transaction. So on this note, I believe that I have completed, kind of, I guess, addressed all the points for this session, right? So I'll stop sharing the screen now.
Couple of questions, sir.
Yes, we can have 5 minutes for the question thing.
What is the use of if term sheet is not a legally bound document?
Okay, so as I was mentioning, in the initial slides, that term sheet shows the soft commitment of the parties, and that's why it is important. It captures the intent of the parties, that the parties are intending to go ahead with the transaction. And that's why I was mentioning that post the execution of term sheet happens, the parties show their intent in different forms, because once the term sheet is executed from investor standpoint, then it proceeds with undertaking the diligence by its advisors. This legal diligence, tax diligence, financial diligence happens, right? From the companies and promoter standpoint, they start providing the information for all those diligence. Then the parties get together to sign a definitive agreement. Of course, now you can say that, what is the sanctity of the term sheet if the party wants to get away from it? Of course, they can. But certain clauses, they cannot really breach it. Like certain clauses, I said that, like confidentiality and exclusivity are the two important clauses which still stay to be binding, which means that even after the signing of the term sheet, the investor cannot misuse the confidential information which is being shared with him by the company and the promoters. That means it cannot go ahead and make unauthorized disclosure of the confidential information. And secondly, the important binding clause is the exclusivity clause. That means that after signing the term sheet, the promoters just cannot roam around and do window shopping and try to have parallel discussions and negotiations with different set of prospective investors for their investment in the company. So these are the two important binding commitments. But apart from that, yes, it is a soft commitment. It is more of a broad understanding of how the transaction, what are the broad contours will look like. That's why, and we will see that at times, and a lot of times, at the time of definitive agreements, when we are drafting and negotiating the share subscription shareholders agreement, a lot of negotiations take place, a lot of positions get changed, what was there in the term sheet. And that's exactly the position, the argument which each respective party takes, that, it was more of a soft commitment. I was not aware. Now I did not use my counsel. I did not use my CA at that point of time. I did not get the sufficient advice. I signed that term in the hurry. We kind of said that we'll take care in the definitive documents. So that's why you will see a lot of these things being discussed at the time of definitive documents, which also can change certain positions, what was agreed in the term sheet.
What, in your opinion, should be ideal holding of equity shares to run the company by the promoters or founders? What should be ideal mix of equity, preference, and debt fund, and ideal number of promoter director in a board of 10 directors?
10 directors?
Yeah.
Okay, now 10 directors is not an ideal number of board, obviously. I mean, if you're talking about 10 directors, I guess we're talking about much more in the company, in the case of a listed company or big public companies. So 10 directors is a very unusual thing. I don't think you will find that in the construct of an VC invested company or a startup, so as to speak. The ideal number, there is no ideal number as such. Obviously, when you're talking about a startup and when a startup is going for its first set of institutional round of funding, it won't want to dilute much because it has got its own set of implications. Diluting a lot of equity in the very first round poses a lot of problems for the founders themselves. One, of course, it sets a benchmark and a precedent. Secondly, when the founder is going for the next round of institutional funding, etc., if the founders are not holding sufficient shareholding, then the prospective investors also do not see a lot of confidence and trust. So, yeah, preferably, let's say 10% to 20% maybe can be the dilution for the founders for the first set of institutional funding by VCs. Ideally, definitely not exceeding 25%, but again, that's also the outer limit I'm talking about. Preference equity really doesn't matter because more often than not, any investor coming with a term sheet will take the preference shares for the reasons I mentioned in my session. So yeah, that's how it works. And debt is something, again, in the initial stages that will depend on the comfort of the founders, the institutional investors. If they need working capital, they'll obviously take debt. But in terms of equity dilution, that's how the construct is: 10 to 20% max dilution for the founders.
Okay. Once again, I would like to say that we are almost grateful to you on this forum. We thank you for being with us in the evening. It is a great pleasure, Mr. Souvik Roy. Thank you from the Committee on MSME and Startup. We are thankful to the listener also, listener and the viewers, on behalf of the Committee on MSME and Startup. We once again thankful to Mr. Souvik Roy for spending his valuable time for this endeavor. Thank you, sir.
Thank you. Thank you, Sambitji. And thank you, of course, to ICAI for inviting me. And thanks a lot to all the participants and attendees. I hope it has been fruitful and beneficial in some way or the other. So look forward to speaking again. Thanks a lot.